meeting, the Revenue Committee meeting at 10:40. Please accept my apologies. I was running late today, so okay. We're gonna do the invocation by Senator Coyote Runs. Lucky. That's all gonna go come on. Okay, get everybody up to speed. On Friday, August 30th, we read this into record in Revenue Committee, the joint action resolution, but we didn't have the loan documents, but we do have them today. And then on Thursday, September 5th, that was the last revenue meeting on the $10 million loan. At that time, it was more of an update on the loan documents, the status of it. It wasn't, they didn't receive it at that time. So I guess the goal and objective today is to have a recommendation for next week, to a recommendation for approval or disapproval by the end of this Revenue Committee today or this morning. And appreciate Vice Chair Dana being here, as well as Bill Watt, Melissa, and also Finance Director Marlon Carlin. So with that, thank you for all showing up for this important matter on the $10 million loan. At this time, we are on the live stream, so we're reading. We're keeping this in record. So since we read this into record, I'm going to hand over the mic to Bill, and we have 3 documents that has been handed out, and we're going to read those into the record. And I believe the first one would be which one are you going to be reading first? The loan agreement into record, and I think Marlon might be reading some because you know, it takes a while to read some of these documents. But okay, I'll hand the floor over to Bill. Bill Watt.
Thank you, Mr. Chairman. I guess I'd ask the Vice Chairman if he had any preliminary comments or anything from the executive. Mr. Chairman, members of the committee, I would just note, as a general matter, the language in the loan agreement, except for the actual amount, the interest rate, and the dates of repayment, and those specific terms, all of these general legal terms are, I believe, precisely the same as they were in the 2007 loan agreement for Little Bighorn College and Library, the 2010 line of credit and the draft documents that we had prepared for that 2011 loan that was not approved. So there's nothing new in here, but it is still worthwhile to review everything that's said here. And so with that in mind, this is entitled the loan agreement, the main agreement. This loan agreement is dated effective as of the blank day of blank 2013 between the Crow Tribe of Indians, a duly organized, existing, and federally recognized Indian tribe of Montana, together with any successors to its functions, and hereafter referred to as the borrower, and First Interstate Bank, a Montana Banking Corporation, together with any successors are permitted to sign hereunder referred to as the bank. Whereas the bank borrower is authorized and empowered by the Crow Tribal Constitution and joint action resolutions of the executive and legislative branches of the Crow Tribal government to borrow money and issue obligations to finance operating costs for land purchases, economic developments, projects, and other purposes, and to pledge the interest the borrower receives from the Crow Tribal Trust Fund as hereinafter defined in accordance with JAR 13-blank, as the same may be amended or supplemented from time to time. And whereas the borrower has applied to the bank for a term loan in the principal amount of $10 million, the quote 2013 loan, unquote, which will be used for the loan purposes defined below. Whereas the borrower previously extended credit in the original principal amount of $3 million to the borrower under loan number 190-332-4410 on April 9, 2013, the quote April 2013 loan. And whereas the execution and delivery of this loan agreement and of the 2013 note as hereinafter defined have been in all respects duly and validly authorized by the borrower. Now therefore, in consideration of the premises and mutual covenants hereinafter contained, the parties hereto do agree as follows. Article 1, Definitions, Rules of Construction, and Appendices. Section 1.1, Definitions. In this loan agreement, unless a different meaning clearly appears from the context, Act means the Crow Boundary Settlement Act of 1994, 25 United States Codes, Section 1776 et sequitur as amended. Applicable rate means with respect to the 2013 loan and the 2013 note, a variable interest rate adjusted annually equal to the prime rate on the date of calculation plus 1.5%, 1.450% per annum. On the date hereof, the applicable rate is 4.75%, derived from the prime rate 3.25% plus 1.50%. Assigned interest income means the interest income on all amounts held in the Crow Tribal Trust Fund, which has been pledged and assigned to the Crow Finance Authority and bond trustee pursuant to that certain pledge and assignment agreement between Crow Finance Authority, the tribe, and the bond trustee, the Crow Boundary Dispute Settlement Agreement, and the Act. Assigned interest income payments mean payments of interest accrued on the principal of the Crow Tribal Trust Fund, which may be made by the OST to the borrower pursuant to the terms of the Act. Assignment means the forced supplemental pledge and assignment agreement dated as of the date hereof, which assigns and pledges the assigned interest income payments by the borrower pursuant to the bank, pursuant to the terms of the Act and this loan agreement. Bank means First Interstate Bank, a Montana Banking Corporation with its principal office in Billings, Montana, and any successor to its powers, duties, and obligations. Bond trustee means the U.S. Bank Trust National Association, formerly known as First Trust National Association, as trustee under trust indenture dated as of January 1, 1998, between the borrower and the bond trustee, governing the repayment of Series 1997 bonds. Borrower means the Crow Tribe of Indians of Montana. Business day means any day which is not a Saturday or Sunday and is not a day on which banks in Montana are authorized or required by law to close. Closing means the date of delivery of the 2013 note to the bank. Collateral documents means the assignment and any other documents and agreements delivered to the bank providing for the payment of or securing the obligations of the borrower under this loan agreement and the 2013 note. Committed amount means the principal amount of the 2013 loan. Counsel means an attorney duly admitted to practice law before the highest court of any state and satisfactory to the bank. Crow Tribal Trust Fund means those certain funds held in trust for the borrower in the Treasury of the United States of America, which were created by the Act and are managed by the OST. Loan purposes means use of the proceeds of the 2013 loan to 1. pay off the April 2013 loan. 2, fund tribal economic development projects and land purchases, and 3, other purposes. Opinion of council means a written opinion of council. Origination fee means a fee equal to 1% of the committed amount retained by the bank from the proceeds of the 2013 loan at closing. OST means the Office of the Special Trustee for American Indians of the United States Department of Interior, together with its successors and permitted assigns. Person means any an individual, corporation, partnership, limited liability company, association, joint venture, joint stock company, or unincorporated organization. Pledge and assignment agreement means the agreement between the Crow Finance Authority, the tribe, and the bond trustee dated as of January 1, 1998, wherein the Crow Finance Authority and the tribe pledge and assign the assigned interest income to the bond trustee to secure certain tribal purpose revenue bonds, Series 1997. Prime rate means the prime rate as published in the money rate section of the Wall Street Journal Western Edition. Second supplemental pledge and assignment agreement means the second supplemental pledge and assignment agreement between the tribe and First Interstate Bank dated as of September 21, 2007, wherein the tribe pledged and assigned the assigned interest income payments to the First Interstate Bank to secure the 2007 note. Series 1997 bonds means the Tribal Purpose Revenue Bonds, Series 1997, issued by the Crow Finance Authority for the purpose of financing the costs of certain projects approved by the Crow Tribal Council pursuant to the terms of that certain trust indenture dated as of January 1, 1998. Supplemental pledge and assignment agreement means a supplemental pledge and assignment agreement between the tribe and First Interstate Bank dated as of February 2, 2000, wherein the tribe pledged and assigned the assigned interest income payments to First Interstate Bank to secure the 2000 notes. Tribe means the Crow Tribe of Indians of Montana, federally recognized Indian tribe. 2000 notes means the Series A note and Series B note taxable of the tribe, each dated February 2, 2000. 2007 note means the Series A note of the tribe dated September 21, 2007. 2013 loan means the loan made to the borrower by the bank in the amount of $10 million to provide funds to the borrower for the loan purposes and to pay the origination fee relating to the 2013 note and other fees and costs related to the 2013 loan incurred by the borrower. 2013 loan repayments means the semi-annual installments of interest and principal payable by a borrower pursuant to Section 5.1A of this loan agreement, along with any other sums then due under the 2013 note, including any prepayments thereof or under this loan agreement with respect to the 2013 loan. 2013 note means the 2013 note in the original principal amount of $10 million dated the date hereof, executed and delivered to the bank to evidence the 2013 loan. Section 1.2, Rules of Interpretation. For all purposes of this loan agreement, except where the context clearly indicates otherwise, A, all accounting terms not otherwise defined herein have the meanings assigned to them in accordance with generally accepted government accounting standards. B, terms in the singular shall include the plural and vice versa. C, all references to time shall refer to Billings, Montana time unless otherwise provided herein. D, all references to mail shall refer to first-class mail postage prepaid. E, words of the masculine gender shall be deemed and construed to include correlative words of the feminine and neuter genders. Yeah, that was the one I got. F, or is not exclusive but is intended to permit or encompass one, more, or all of the alternatives conjoined. Section 1.3, appendices attached to this loan agreement hereby made a part hereof are the following appendices. Appendix A, the form of the 2013 note. Appendix B, the form of the assignment. Appendix C, dispute resolution and limited waiver of sovereign immunity. Appendix D, pending litigation. Mr. Chairman, with your leave, I thought I would inquire at this point if Chairman Okayo wanted to say anything before I read the rest of this thing. And he has indicated no. Article 2, Representations and Covenants. Section 2.1, Representations. The borrower represents as follows. A, organization and authority. The borrower, 1, is a duly organized and validly existing Indian tribe. 2, has all requisite power and authority as of the date hereof to execute this loan agreement, enter into the collateral documents, issue the 2013 note, and carry out and consummate all transactions contemplated by this loan agreement, the 2013 loan, and the collateral documents. And 3, has taken all proper action to authorize the execution, delivery, and performance of its obligations under this loan agreement, the 2013 note, and the collateral documents, and the incurrence of the debt evidenced by the 2013 note and the maximum amount of the committed amount. B, pending litigation. Except as described in Appendix D, there is no litigation or proceeding pending or to the knowledge of the borrower threatened against or affecting the borrower in any court or before or by any governmental authority or arbitration board or tribunal that, if adversely determined, will materially and adversely affect the existence, corporate or otherwise, of the borrower or the ability of the borrower to make all payments and otherwise perform its obligations under this loan agreement, the 2013 note, and the collateral documents, or the financial condition of the borrower or the transactions contemplated by this loan agreement, the 2013 note, and the collateral documents, or the validity and enforceability of this loan agreement, the 2013 note, and the collateral documents. No referendum petition or other petition has been filed with respect to any resolution or other action of the borrower relating to the 2013 loan, the 2013 note, or any collateral documents. C, borrowing legal and authorized. The execution and delivery of this loan agreement, the 2013 note, and the collateral documents, and the consummation of the transaction provided for in this loan agreement, the 2013 note, and the collateral documents, in compliance by the borrower with the provisions of this loan agreement, the 2013 note, and the collateral documents, 1, are within the powers of the borrower and have been duly authorized by all action necessary on the part of the borrower, and 2, do not and will not constitute in any breach of any of the terms, or will not result in any breach of any of the terms, conditions, or provisions of, or constitute a default under, or result in the creation or imposition of any lien, charge, or encumbrance upon any property or assets of the borrower pursuant to any resolution, indenture, loan agreement, or other agreement or instrument other than this loan agreement and any collateral documents to which the borrower is a party or by which the borrower or its property may be bound, nor will such action result in any violation of the provisions of the Constitution of the borrower or any laws, ordinances, governmental rules, or regulations, or court or other governmental orders to which the borrower, its properties, or operations are subject. D, no defaults. No event has occurred and no condition exists that upon execution and delivery of the 2013 note and the collateral documents will constitute a default under this loan agreement or the collateral documents. The borrower is not in violation of any term of any agreement, resolution, trust, indenture, charter, or other instrument to which it is a party or by which it or its property may be bound, which violation would materially and adversely affect the transactions contemplated hereby, or the compliance by the borrower with the terms hereof, or the 2013 note and the collateral documents. E, governmental consent. The borrower has obtained or made all findings and approvals required to the date of this loan agreement by any governmental authority or officer for the making and performance of the borrower of its obligations under this loan agreement, the 2013 note, and the collateral documents. No consent, approval, or authorization of, or filing, registration, or qualification with any governmental authority other than those, if any, already obtained or which will be obtained prior to closing is required on the part of the borrower as a condition to executing this loan agreement, issuing the 2013 note, or entering into the collateral documents and the performance of the borrower's obligations hereunder and thereunder. F, binding obligation. This loan agreement, the 2013 note, and any collateral document to which the borrower is a party are the valid and binding obligations and agreements of the borrower, enforceable against the borrower in accordance with their terms, except to the extent that the enforceability thereof may be limited by laws relating to bankruptcy, moratorium, reorganization, insolvency, or similar laws affecting creditors' rights and general principles of equity. G, full disclosure. There is no fact that the borrower has not specifically disclosed in writing to the bank that materially and adversely affects, or so far as the borrower can now foresee, except for pending or proposed legislations or regulations that are a matter of general public information, that will materially and adversely affect the property's operation and financing of the borrower or the borrower's ability to perform its obligations under this loan agreement, the 2013 note, and the collateral documents, and to pledge any revenues or other property pledged to the payment of the 2013 note. H, compliance with law. The borrower is in compliance with all laws, ordinances, governmental rules, and regulations, and the court or other governmental orders, judgments, and decrees to which it is subject and which are material to the property's operation and financing of the borrower or its status as an Indian tribal government. Section 2.2, covenants. A, right of inspection and notice of change of location. The bank and its designated agent shall have the right at all reasonable times during normal business hours and upon reasonable notice to enter into and upon the property of the borrower for the purpose of inspecting books and records of the borrower relevant to the performance of borrower's obligations under this loan agreement, the 2013 note, and any collateral documents. B, further assurance. The borrower shall execute and deliver to the bank all such documents and instruments and do all such other acts and things as may be necessary or required by the bank to enable the bank to exercise and enforce in accordance with the provisions of section 11.7 below and paragraph 7 of the 2013 note, its rights under this loan agreement, the 2013 note, and the collateral documents, and to realize thereon, and record and file and re-record and refile all such documents and instruments at such times in such manner and at such place or places, all as may be necessary or required by the bank to validate, preserve, and protect the position of the bank under this loan agreement, the 2013 note, and the collateral documents. C, maintenance of security, if any, recordation of interest. 1, the borrower shall at its expense take all necessary action to maintain and preserve the assignment of revenues provided for in the assignment for so long as any amount is owing under this loan agreement or the 2013 note. 2, the borrower agrees to execute and deliver such financing documents, continuation statements, or other documents that may be necessary, and to take whatever other action may be requested by a bank to perfect and continue the bank's interest in the assigned interest income payments pursuant to the assignment. In connection therewith, the borrower hereby irrevocably authorizes the bank to cause financing statements and the amendments thereto and continuations thereof, and other documents that may be necessary to be recorded and filed at